Greetings, everyone. Welcome to the 18th International Conference on Artificial Intelligence and Law. My name is Fernanda Suriani, and this is the second panel of the second day of the event. I'm very glad to be here with you. It's an honor for me to share these moments with all these brilliant panelists. Before starting the panel, I'd like to thank our sponsors. Our platinum sponsors are JUS Brazil and Albert Einstein Israeli Hospital. JUS Brazil is currently the #1 law and government website worldwide, with 28 million unique users each month that makes high-value legal information super easy and quick to access, thus saving its users time and providing substance for their case strategies and insights. Our other platinum sponsor is Albert Einstein Israeli Hospital, one of the best-known health units in Brazil and Latin America for the quality of care and for the equipment and medical specialties available to treat many types of pathologies, the heart activities. Now I'd like to introduce Ms. Heng Zhang, who will present the full paper with the title Hardness of Case-Based Decisions, a Formal Theory. The stage is yours, please.
Thank you. I'm now going to share my screen. Yes. Hello, everyone. My name is Heng Zheng. I'm a PhD student from the University of Groningen. Today, I'm going to talk about our paper, Hardness of Case-Based Decisions, a Formal Theory. Following precedents is a fundamental principle of case-based reasoning, but the application of it varies in complexity. Legal decision-making can still be very hard. This puzzle has been well recognized in AI and law since its early days. For instance, in Anne Gardner's landmark work, An Artificial Intelligence Approach to Legal Reasoning, she addresses the distinction between hard and easy cases by using ideas from jurisprudence. The hardness of case-based decisions can come in different types. Some cases are easier to decide. However, things can become harder. For instance, not all conflicts can be resolved, or there is no matching precedent. Significant work has been devoted to the nature and dynamics of case-based reasoning and to the hard cases as well. However, to the best of our knowledge, no formal theory about the hardness of cases has been proposed so far in the field of AI and law. So in this paper, we are going to discuss this question. Is there a typology of how hard it is to make a decision about an issue in case-based reasoning? We propose a formal approach written in propositional logic to formalize the hardness of decision-making issues with the validities of relevant arguments. We also illustrate the approach with a case study in the dynamics of case-based reasoning by following Berman and Hafner's research, thereby showing how hardness varies over time. This slide shows the 7 cases that we are going to discuss, which aims to solve tort cases about car accidents from New York. With the elements extracted from these cases, we got 7 conjunctions to represent them. They are represented by the plaintiff's name, the year of the decision, the kind of case, either a tort case or a contract case. and the jurisdiction choice rule. We need to consider which rule should be applied when different jurisdictions are relevant. For instance, when people drive from New York and have an accident in Ontario, Canada, which rule should be followed? Ontario's rule or New York's rule? Here, territory is for entirely applying the territorial rule. Exception is for partly applying the territorial rule while making an exception for the damages part of the case. And gravity is for applying the center of gravity rule. In this paper, we try to apply our approach to solve problems such as if there were only these two precedents can be considered, how hard it is to apply the territory rule in an undecided tort case that arose after 1945. And what about the hardness of applying the center of gravity rule? And after new cases were added, does the hardness of applying rules change? And does it become harder or easier? In general, we consider these four issues of the New York cases, namely whether to apply the territory rule in tort case or not, whether to apply the gravity rule in general, whether to apply the exception about the territory rule, and whether apply the gravity rule in tort law. As you can see from this picture, there was an agreement in decisions that the territory rule should be applied in 1938, so decision-making was easy at that time. However, from 1945, alternative possibilities were explored. First is for contract cases, then also for a tort law case called the Cuba case in 1961. Therefore, case-based decision-making becomes harder since there are different possibilities and without a clear preference. And then in 1963, things again became easier, since the landmark Babcock case expresses a clear preference for the gravity rule. Now we turn to the theory part of the paper. First, we are going to introduce case models. We describe a case model C as a set of logical consistent incompatible cases, forming a total pre-order that represents a preference relation among the cases. For example, the New York cases we just introduced can form a case model. And please notice that we consider the plaintiff names to exclude each other pairwise. And similarly, for the decision years, the kind of the cases and the rules. The preference relation among these cases is denoted by the size of these boxes. And namely, the Babcock case is more preferred than other cases, which are equally preferred. This is because the Babcock case is a landmark case that overrides previous cases, by which the center of gravity rule is established for tort law. And we consider an argument from chi to rho is a pair chi-rho, where chi is the full premise of the argument, rho is the full conclusion, and chi and rho is the full position made by the argument. According to the preference of a case model, arguments can have three kinds of validities in the model, from weak to strong, are coherence, presumptiveness, and conclusiveness. The relation between these validities can be illustrated by this Venn diagram. Conclusive arguments are also presumptively valid, and presumptive arguments are also coherently valid. and all the precedents are either coherent or incoherent. If an argument is incoherent, then it is outside the set of coherent arguments. Every argument can be attached to a label based on its validity in the model. An argument with a conc label are those conclusive arguments. An argument with a pres label is an argument that are presumptively valid but not conclusive. An argument with a co-label is coherently valid but not presumptively valid in the case model. And label inco is used for arguments that are not coherent. These arguments are in the set of all arguments, but not in the set of coherent arguments. We consider the validity labels come with an ordering. Intuitively, based on their validities, arguments with label conc are stronger than arguments with label pres. Similarly, pres is stronger than co, and co is stronger than inco. With this ordering, we can quantify how far apart the labels are. We call the validity distance between two arguments is the number of steps in the validity ordering that are needed to go from the label of the weaker argument to the label of the stronger one. As the ordering has a length 3, the maximal validity distance is 3, and the minimal is 0. For instance, from conc to inco, the distance is 3, while from co to co, the distance is 0. With arguments and their validity labels, we can define issues for discussing the question about hardness. Formally, we represent an issue as sigma plus minus iota, where sigma is a sentence for a given situation. Iota is a sentence as an issue about the situation. Both iota and not iota are not logically implied by sigma. For every issue, there are two naturally associated arguments, namely sigma iota and sigma not iota. For example, when we think of whether to apply the territory rule in tort cases, we consider issue tort plus minus territory, where argument tort territory is for applying the territory rule, and argument tort not territory is for not applying the rule. Similarly, whether to apply the gravity rule in tort law is connected with issue tort plus minus gravity. Whether to apply the exception about the territory rule is connected with issue tort plus minus exception. And whether considering gravity in general is represented with the issue tautology plus minus gravity. The type of an issue sigma plus minus iota in the case model C is represented as a multiset consisting of the validity labels of the two associated arguments. For instance, if the argument for applying the territory rule is with label conc, and the argument for not applying the rule is with label inco, then the issue tort plus minus territory is with type conc inco. And by the definition of arguments validity in our paper, not all types are logically possible. Now we show in total 7 possible issue types. And we view hardness of issues, of types of issues, as a relation between types of issues in different case models. Intuitively, a type of issues is easier than another one if and only if the greater the difference between the validity of its associated arguments, or the stronger the validity of the associated arguments. For instance, Kong-Inco is easier than press-press, since the difference between Kong-Inco is greater than the difference between press-press. And since the validity strength of press is stronger than Inco, we consider press-press is easier than Inco-Inco. As shown by the Haas diagram, in our definition, an issue type that is higher in the ordering is easier. Formally, the hardness ordering is based on the lexicographic combination of two orderings among the types of issues. We first compare the types in D-ordering. Higher types in D-ordering involve further validity distance between the labels within types. And higher in D-ordering means the type is also easier. For instance, the validity distance between Kong and Inco is 3, and the distance between press and Inco is 2. Therefore, by the D-ordering, we consider Kong-Inco is easier than press-Inco. However, if the types are with the same validity distance in D-ordering, then we can turn to the V-ordering. Higher in the V-ordering means issues involving stronger arguments. Therefore, higher in the V-ordering means the type is also easier. For instance, the validity distance of both type press-press and co-co are equal to 0. In this case, we cannot compare their hardness in terms of the D-ordering, and we need to use the V-ordering to decide which one is harder and which one is easier. Since press is stronger than co in the V-ordering, we consider press-press is easier than co-co. The Haas diagrams in this slide shows our definition of hardness is well-behaved, since it is transitive and can be used for comparing any pair of issue types. Now we connect the hardness ordering with the development of hardness of applying rules in the New York cases. As we discussed before, the hardness of an issue is determined by the validity of the arguments that it associates with. And with new cases being added, the hardness of applying rules will change accordingly. For instance, the hardness of issue taught plus minus territory is with type Kong-Inco in 1938. When it becomes harder in 1963, it is with type press-co. In general, we figure out that when the gravity rule was introduced in general in 1954, issue tautology plus minus gravity became harder. Similarly, when the gravity rule was introduced to the tort law domain in 1963, issue tort plus minus gravity also became harder. And we also observed that issue tort plus minus territory became harder correspondingly when the court showed doubt on the territory rule by making an exception for the damages part of a tort case in 1961. And in 1963, when the gravity rule was introduced by a landmark case called Babcock case, with higher preference, not only issue tort plus minus gravity became harder, but also other issues are become easier. After
Hank,
finally
sorry.
making the...
Hank, you have 5 more minutes, okay?
Okay. After finally making the gravity rule as the primary one in 1963, the 4 issues remain the same hardness type press code as in 1938, when the primary one is the territory, and they are all with type cone inco. This shows that more options makes the consideration of applying rules becomes harder than in 1938. So in conclusion, we model the hardness of issues of case-based decisions in terms of arguments and their validities, and define an ordering that shows which issues are harder and which is easier. We also apply our approach to discuss the hardness of the issues in the context of dynamics of case-based reasoning. So the hardness approach we introduce is relevant in the understanding of case-based decision-making and can be applied in other domains where example-based reasoning is reasonable. And it can also lead to insights on the hardness of decision-making in hybrid AI systems involving both knowledge and data. Thank you for your attention.
Thank you very much. We have some questions for you. So the first one is, in your paper, the model case-based decision-making is applied in common law jurisdictions. Do you think it's possible to apply this model in civil law jurisdictions?
Yeah, thank you for the question. It's very interesting, but since it's a very initial research, currently we just apply it to the case law domain, but we believe that it can also be applied to the civil law domain because one of our previous paper shows that it can be, the case model can also be applied in the Dutch civil law system. So yeah, I think it's possible.
Okay, and another question. There are earlier attempts to formalize the distinction between hard and easy cases. For example, Gordon in 1991 and Preke in 1993. Gordon also formalized the notion of an issue. What does your approach add to their work?
Yeah, it's a very interesting question. Thank you for that. But we haven't, I haven't looked at Gordon's work yet. So yeah, our approach is based on recently developed case model formalism by Bart. So yeah, it's in a formal propositional logic. Yeah.
Okay, thank you very much. Do you like to say a few more words before we go to the other panelists?
Yeah, I think that's it. Thank you for attention.
Okay, thank you very much. Now I would like to introduce you to Mr. Trevor Bench-Capon, who will present the full paper with the title Precedential Constraint, the Role of Issues. Very welcome, Mr. Trevor. The stage is yours.
Thank you. Can everyone see my screen? Can everyone see it?
Not yet, just a moment.
It's cold.
It's not coming. Can you try it again, please? Yes, now we can see.
Okay, thank you. This is your work with Casey Atkinson, who you see there in happier ways when we can actually meet at the time. That's in San Diego. My paper has 3 topics: the relation between factors, dimensions, and facts. And I will argue that precedential constraint is best expressed in terms of factors. and factors are assigned to applicable dimensions on the basis of facts. Precedents constrain issues is the second point, and it's issues that constrain cases. So when thinking about precedents, you also think about issues, not cases as a whole. Factors in cases should be structured into issues to avoid irrelevant issues. And the third topic is precedential constraint only needs factors. We don't need to express precedential constraint in terms of dimension. Where magnitudes are important, and they are important, we first apply factors on the basis of dimensional facts, and then we apply constraints. So the history of understanding precedential constraint is a lengthy one. At the very first edition, Edwina Rusland and Heliassi presented a paper which understood them in terms of dimension. In 1985 onwards, Cato, with Vincent Leland and Heliassi, introduced the notion of factors. Then Henry Plachen and Giovanni Starfield showed us how we could write precedents as rules. My contribution in 1999 was to consider the antecedents organized in partial order. And then still ongoing is work in formal characterization of precedential constraint. Began by John Hawking, continued by Adam Biennially, and summarized by Henry Plachen in a paper this year. So, how do we move from dimensions to factors? The dimensions tell us what needs to be considered in a case. If the dimension is applicable, it may, not must, it may provide a reason to decide for one of the parties. These reasons are referred as factors. Factors refer the significance of the dimension in the particular case. Sometimes the dimension is either inapplicable or favours one side, in which case it will correspond to one factor. Sometimes it's inapplicable or neutral or favours a side, and the dimension may have more than one factor favouring the side to differentiate different degrees of favour. And sometimes the dimension may be neutral, or it may favour either side. And this dimension has distinct factors to the different sides. Factors should never be related. An action factor may be inapplicable, it may be neutral, it may be a factor for the other side, or a different, stronger or weaker factor to the same side. It's confusing to bundle these very different things under relation. So, moving from the dimension to a factor, let's consider the disclosure dimension. If we have no disclosures at all, the dimension is inapplicable. An insignificant number will lead to no factor. A significant number will lead to a factor, S same in paper. And in the public domain, we have the very strong co-dependent factor, S27 in paper. So as we move along the dimension, it's first inapplicable, then neutral, then dependent, then strongly dependent. It never favours the same. Another dimension, security measures can favour both the plaintiff and the defendant. So we have two distinct factors, S19 and S6. S19 applies if the measures are inadequate. S6 applies if they're adequate. So the dimension is always applicable, but there's a neutral area in which no factor applies. Precedents determine where these switching points occur. S19 is not related to the aspect. It provides a reason for the defendant, but the neutral range does not. So now we consider how can we write precedents as a set of rules. A case can be seen as P union V implies O, where P is the plaintiff factors, V the defendant factors, and O the outcome. So P is the strongest reason assigned to the plaintiff. V is the strongest reason assigned to the defendant. And O will be either plaintiff or defendant and will show which of these reasons is preferred. So we get three rules: a plaintiff rule, a defendant rule, and a rule expressing a preference between these, depending on the outcome. We can represent this graphically by representing the possible antecedents as two parts rules. The one on the left to the plaintiff, the one on the right to the defendant. Now a precedent will place an arc between these rules. So if we have A, B, C, D, E decided to the plaintiff, that shows that A, B, C is preferred to D, E. If B, C, D, E is decided to the defendant, that shows that D is preferred to B, C. Now if we have a U case, it's constrained if it's a reproducible cycle. If we have a case A, B, C, E, then we can put the arrow at either end and there's no cycle. So we can do what we like with cycle. However, if we have C, D, E, that's constrained to the defendant. If we were to decide to the plaintiff and prefer C to D, E, we would introduce the cycle. We can't have a cycle, and so we have to decide to the defendant. This basic idea has been formalized starting with John 40, going on to Latin with Henry, and finishing this year with Henry Buck. And there's a list of the papers. The formalization is rigorous, and it shows that all the desirable properties we would want to hold do in fact hold. And it comes in two forms: the results model and the reason model. The results model uses all available factors. No interpretation is needed. Both sides offer their strongest reason. But, unfortunately, it does not in fact constrain many cases. It only supports a tutorial reason. The new case, if it is to be constrained, must be subsumed under the pressure. But we want more than this. We want to be able to argue for cases which, while not subsumed, are constrained by the pressure. Suppose we have a case with security measures, invasive techniques, and disclosures are outside, and a precedent which has similar factors, but also the unique product. We want to say that the use of invasive techniques, such as wiretapping, is sufficient. The actual uniqueness of the product as little. But on the results model, the precedent does not bind because SAC is not there. And this is even though we have a much stronger factor S6 in the new case. To rectify this, forcing to use the reason model. Now the reason model contains only a subset of the available factors. It represents a sufficient reason which, although it's not the strongest reason, is still enough to defeat the opposing reason. The losing rule still has all available factors, and the reason model has the same formal properties as the result model. But there are three problems. How to determine which factors constitute the reason? It's possible that cases are reinterpreted in the light of new decisions, which would disrespect the reason model rather than obeying the results model. And even the results reason model does not constrain enough cases. Irrelevant distinctions are still possible. To find the answers to this problem, we look back to issue-based prediction, which was introduced by Jeffrey Bloominghouse and Kevin Apple. Whereas Plato was designed to generate arguments, not to predict outcomes. So it didn't matter whether there was constraint or not. The user evaluated the argument. But when Plato was adapted to prediction by Jeffrey and Kevin, they found that Plato abstained on far too many cases. Plato was considering irrelevant distinctions, like the unique product in the example earlier. So Plato instead considered cases issue by issue rather than as a whole. So IBP considered cases issue by issue. And this conforms nicely with the IAAIL model, widely taught in law schools, where we analyze a case into the issue, the rule governing the issue, not the case as a whole, the application of the rule and the conclusion. So I would argue that thinking in terms of issues rather than cases conforms to this widely used method of reason analysis. The issues form a logical model. They're related logically, and so there's no need to balance them. Once the factors are resolved and the various least nodes are known, then we can infer the conclusion. So what is the role of factors? The role of factors is to determine the legitimacy of the logical model. Each issue is associated with a small group of factors. Factors can relate to more than one issue. And because fewer factors are involved at the issue level, the decision is much more likely to be constrained. There are 8,192 possible antecedents for both the defendant and the plaintiff in paper. So imagine the size of the lattice that we have to the past laws. However, there are never more than 32 possible antecedents for any issue in IDP. And this enables us to ignore irrelevant distinctions. In the paper, I have a full-worked example, but because of the time available, I will jump straight to the last case. The case in question is Boeing, which considers certain manufacture of aircraft windows, cockpit windows. There are a number of relevant precedents: national instruments, television, which is about a PBX, and Bryce, which is about software methodology. And we can see that these cases are, in some respects, similar to Boeing. Boeing is identical to television on the grounds of secrecy, and it's identical to Bryce with respect to the confidential relationship. None of the issues are in Boeing are opposed. Information valuable simply is accepted, and improper means of info used was established by the use of respective material. So we really want Boeing to be constrained because television solves the issue of secrecy, and Bryce solves, or rational inference, which Bryce followed, solves the issue of confidential relationship. But on both the results and reason models, F1 will distinguish television, and F10 will distinguish Bryce and rational inference. It's only if we think in terms of issues that we can constrain Boeing using television for secrecy and rational instruments for confidential relationship. And this is what we've done. So the argument is that we actually need to incorporate the domain knowledge, the knowledge of the structural cases represented by issues. This is because we want Mason and we want Boeing to be constrained by the precedents in the example. And issues are needed so that the irrelevant differences can be ignored and the cases constrained. Preferences are correctly located at the issue level. And this was recognized by Carl Brankin as one of those 1991 newspaper losing the portion of It was exploited by IBP in ICAIL 2003, but is still currently not exploited in the former House of Precedential Constraint, as represented by Henry Paperwork. Also, for explanation in terms of values, issues allow values origins to be local to issues rather than global, and the global requirement has presented problems in the past for value-based explanation. Now we'll come on to the third topic, factors of magnitude. Many factors seem to have a continuous favour. The number of disclosures from brought to many thousands. The extent of security measures from minimal to performance. The ease of research engineering. I know that at advance, but it may take me several years of study and experiment. The length of stay in various domiciles. And all these look like dimensions rather than factors. So how do they work with precedential constraints? This has recently been explored by the usual suspects, John Halsey, Adam Mahoney, Henry Patton, and even by myself to some extent. The question is, do we need to change our account of precedential constraints to accommodate dimensions? And our answer is no. Precedential constraint uses factors, not dimensions. And the reason for this is reasoning with precedents involves two stages. Firstly, we identify the factors, sometimes termed intermediate precedents in the literature, on the basis of facts. And we find this in jurisprudence, what is a taboo paper. We find it in AI law, Ashley and Willingham. We find it in jurisprudence again, with Larsinger and others, and we find it in AI law in Pattern et al. Identifying constraining precedents by comparing factors is the second stage. We shall visualize materiality in the first stage. Consider, for example, disclosures. The number of disclosures is a dimension, ranging from naught to very many. However, the particular number of disclosures in a particular case is a fact. If it's naught, the dimension is impossible, there's no factor. If it's a very small number, there is no factor because it's not significant enough. If there are many, the factor is less 10. And if it's in the public domain, the factor is x27, the very strong dependent factor. And of course, which factor applies may be determined by precedent. I also want to say something about trade-off. Sometimes factors are not independent. Look at the example from Pattern and Sartor used by John Porter. This concerns the same as fiscal homicide. It depends on the length of stay and the percentage of income from abroad. The shorter the stay, the bigger the percentage needed. Absence and percentage, as I mentioned, and in a particular case, the particular absence and particular percentage of facts. The factor is income sufficient with an absence. And once the factor is realized, we can apply precedential constraint to it in terms of facts. As an example, consider the trade-off between income and absence. There's precedent 1 at 66, precedent 2 at 28, and precedent 3 at 2010. Clearly, there's a trade-off because we have the same percentage, but a different factor because of a different length of stay. The precedents show that this area, the area to the northwest of the line, does not apply, and the factor applies northwest, but it does not apply southeast of that line. And so we can fit a line to show the trade-off. Several lines are possible. This one is most generous to the node center. So,
Trevor,
to summarize, there are different roles for precedents.
sorry, Mr. Trevor, 5 more minutes, okay?
I'll only get 2 more slides. There are framework precedents identified by Rhetorical in the IAAIL 2015. And these tell us what the issues are. And the issues can also come from statutes and documents that the statement supports. Then there are restriction precedents, and these determine whether a factor applies on the fact. E.g., 12 months is a short stay, 3 years is a long stay. And we can use either the results or the reason model to factor restriction. Finally, there are traditional precedent precedents. These are the standard sort of questions found in paper. And these establish which side has to respond to these. And then they also indicate values. And that's also.
Thank you very much. Well, we won't have time for questions, but in the other panel, when we're going to stream it, then we can have the questions answered, okay?
And I thought the session was half an hour. Are they saying 20 minutes?
Sorry?
It's only 10:02. Let's start at 1.
Oh, one question. You want to answer one question then?
No, I'm saying that you have 10 minutes then before the next paper.
Okay, so, okay, let's have a
The
question.
last, I think, that is answered.
So, does your account of factors and dimensions presuppose that for every value of a dimension, it can be determined which side it favors, if any, is from Praken?
The answer is yes, this is presupposed, but it's also the fact of legal decision. When factors linked to use in legal opinion, it is always clear which side is favored. For particular dimensions of fact, such as length of stay, there is sometimes not clear which side is favored. And this is why we turn to restriction questions.
Okay, thank you very much. And now I would like to introduce you to Ms. Paheli Bhattacharya, who will present the full paper with the title Incorporating Domain Knowledge for Extractive Summarization of Legal Case Documents. The stage is yours. Thank you. We can see your slides. You can go on. Thanks. You are muted. Please, your microphone.
Welcome, everyone.
Yeah.
I am Paheli Bhattacharya from the Department of Computer Science and Engineering at IIT Kharagpur, India. I will be presenting our work, Incorporating Domain Knowledge for Extractive Summarization of Legal Case Documents. So case documents are inherently very lengthy, free-flowing, unstructured, and dense legal text. Reading and understanding these documents is difficult even for legal experts. Therefore, it is necessary to summarize these case documents. Existing legal IR systems employ attorneys or paralegals to manually write summaries. This incurs a high subscription cost of these systems. This calls for the need of developing automatic summarization systems with the overall objective to improve the legal understanding with lesser dependence upon experts. Now, document summarization is not a new problem. There are methods for news document summarization, scientific article summarization, and so on. Let us see what is different in legal case documents. So on the left, there is a news document. So as we see that it is a very short document and the first paragraph usually summarizes these news documents. Next, there is a snippet of a scientific document, particularly a research article. So these documents are lengthy, but they are segmented into sections and subsections with paragraph headings. On the right, you can see a case document from the Supreme Court of India. These documents are lengthy and it is just a free-flowing text with no section headings. There is something called rhetorical segments in a legal case document, but these segments are often not explicitly mentioned. Let us understand what these rhetorical segments are. So rhetorical segments or labels in a case document are the semantic functions which sentences in a case document plays. So these are usually one of the following labels. Facts, that is the sentences that denote the chronology of events that led to filing the case. There are sentences that denote the legal issues being discussed, so we call them as issue. There are also sentences that denote the ruling or judgments given at the lower courts, so we call them ruling by lower court. Similarly, there are arguments by the contending parties, which we call as argument. Sentences that have citations to established laws by the current case, which we call as the label statute. There are also citations to prior cases, and we call these sentences as precedent. There are sentences that describe the rationale or the reasoning of the court for the final ruling, and we call them as ratio of the decision. And finally, the sentences that give the final judgment or the conclusion of the court. So on the right, this is an illustrative example of how a case document, when the sentences are labeled with each of these rhetorical labels, looks like. So the first approximately four sentences have been labeled as facts. Then some sentences have been labeled as issue. Then one sentence has been labeled as ruling by lower court, and so on. So legal experts have some guidelines on how to summarize a case document. Some of these guidelines from USA and UK are given in the links below. We also discussed with law experts from India, and all of them basically devise the following set of guidelines. So the first one is that each rhetorical segment should be summarized well and have representation in the final summary. This is because often law practitioners or academicians or others wish to read only the summary of particular segments. Example, summary of only the facts or summary of only the ratio. So this following this guideline is important. Second is that each of these segments should also, the important parts of each segment should be present in the summary. For example, from the statute segment, sentences that cite the relevant acts or laws should be present. Now let us see what are the existing methods for case document summarization. In this work, we are considering extractive text summarization algorithms. So they can be broadly classified into two main families, domain independent and legal domain specific. And under each of these families, there are supervised and unsupervised methods. So under domain independent supervised methods, we have the state-of-the-art deep learning models like SummaRunner, BERTSum, and so on. So as these are deep learning models, they require huge amounts of training data, which is expensive to obtain in the legal domain. Also, these methods were developed and evaluated on news documents, which are short. But when we apply them to summarize lengthy case documents, these algorithms become very resource intensive. Coming to unsupervised domain independent methods, so they can actually summarize any document. So they do not incorporate any legal domain specific knowledge. Now coming to the second family of methods, legal domain specific. The first one is the GIST method, which is supervised. As it is a supervised method, it requires large amounts of training data. Also, although it is legal domain specific, but there were no domain specific attributes such as rhetorical labels considered in this algorithm. Finally, there are many legal domain specific unsupervised methods. So case summarizer is one, but this algorithm does not assume the presence of any rhetorical role. So they rank sentences based on some importance score, but this score is based on a heuristic where there is no parameter from the rhetorical role perspective. The other three methods, LETSUM, KMM, and MMR, uses a rhetorical information, but just to display the summary in a templatic format. It does not use rhetorical information in estimating the importance of sentences for generating the summary. For instance, LETSUM uses TF-IDF to measure the importance of the sentences. In short, there are two main drawbacks of the prior works. The first one is that the existing algorithms do not incorporate legal domain-specific knowledge systematically. While the supervised methods are expected to learn these rules automatically, there are two disadvantages. First is that there is a scarcity of expert written summaries in large amounts to be used as training data. Secondly, summary requirement may vary for different stakeholders. For example, a journalist who is briefing a case wants a different type of a summary. Maybe he or she wants the ratio to be summarized well, whereas a law practitioner may want the facts and arguments to be summarized well. So it is not practical to gather huge amounts of training data to cater to each type of the stakeholders. So in this work, we propose DELSUM, which is an unsupervised domain adaptive extractive legal summarization algorithm. DELSUM works in an optimization framework to incorporate legal domain knowledge into an objective function with constraints, and this objective function is maximized using integer linear programming. So DELSUM takes as input a document where each sentence is labeled with a rhetorical role and the desired length of the summary in number of words. Let us call that L. So given these two inputs, DELSUM produces a summary of at most L words. So the optimization framework of DELSUM has two main components. The first is the informativeness of a sentence. It measures the amount of important information contained in a sentence. We assume that domain experts will define how to estimate the informativeness of a sentence. The second one is the content words, that is the words that signify domain-specific vocabulary. With each content word is a score which shows how important that content word is. Again, we assume that domain experts will define what the content words are and how the scores are defined. DELSUM produces a summary that maximizes the following objective function. That is, it tries to maximize the inclusion of informative sentences and the number of important content words, subject to constraints that the summary length should not exceed L words. And there are other constraints, so please refer to our paper for more details on this. Now let us see how the legal expert guidelines can be incorporated into DELSUM. In this work, we considered summarizing Indian Supreme Court case documents, and our experts are the senior law students and a professor from the Rajiv Gandhi School of Intellectual Property Law, which is a reputed law school in India. So the first guideline they gave us is that in general, the summary should contain representations from all segments of a case document, and the relative importance of segments in the summary should be as follows. So first and foremost are the final judgment and the issue. Next comes the facts. Then the statutes, precedents, and ratio are of approximately same weightage. And then comes arguments. And the other label, ruling by lower court, is not so important to be included in the summary and may as well be discarded. So we formalize this in DELSUM as follows. So we have a variable called weight K, which defines the weights of each of these segments, and we assign the highest weight to the segment's final judgment and issue. And for the other segments, the weights decrease exponentially or linearly. We may as well assign discrete scores to or discrete weights to each of these segments. The second guideline is that the segment's final judgment and issue are exceptionally important in the summary. The segments are usually very short, and so they should be included completely in the summary. And to ensure a balanced representation, a minimum of 2 sentences from the other segments should be included. We formalize this guideline in DELSUM as follows. We have a variable NOS or number of sentences for a segment K, defined as follows, that if the segment is final judgment or issue, then all of the sentences should be taken. Otherwise, a minimum of 2 sentences should be taken. The third guideline is that the important sentences should be decided based on which segment that sentence belongs to and also other factors. If the sentence is from fact, then we will take the weight of the segment fact and also the inverse of the position of the sentence. If the sentences are from the segment statute, then we will see if the sentence contains citations to an act. So for that, we keep a indicator variable AI for statute, and this AI is 1 if there is a citation to an act, otherwise 0. Similarly, for precedents, we see if the sentences contain citations to prior cases. And for the segment ratio, the guideline is that the sentences appearing at the end of the document and those that discuss relevant statutes and precedents are important. So to formalize this, we assign the weight of the segment ratio, that is weight K, the position of the sentence, and whether there is a mention of statute or a precedent. The final guideline is that the summary must contain sentences that give important details of the case, including acts and sections of acts that were referred, names of people and places, and also sentences containing specific legal keywords are important. So we formalize this by having 3 types of content words. The first one is the acts or sections of acts, to which we assign a score of 5. The second type of content words are the keywords from a legal dictionary, to which we assign a score of 3. And then we have the noun phrases, to which we assign a score of 1. Now, let us see the dataset and experimental details of this paper. So in this work, we considered 50 Indian Supreme Court case documents, where each sentence of a document was labeled with one of the 8 rhetorical segments. So this dataset is available from our prior work. Each of these 50 documents had gold standard summaries written by 2 senior law students from the Rajiv Gandhi School of Law. They wrote segment-wise summaries and they combined ratio and precedent into one segment analysis. The summary lengths were approximately 30% of the original document, and we had 2 sets of summaries. The metrics, the evaluation metrics we considered are the rule scores between the gold standard summaries and the algorithmic summaries. We considered several baselines. So from the 4 families, which I described in one of my earlier slides. So from the unsupervised family, we have domain independent as well as legal domain specific methods. And from supervised also, we have domain independent and domain specific methods. So the supervised methods were trained on 7,100 document summary pairs. So details of this training mechanism can be found in our paper. So now let's see the results of the approaches and also some analysis. So this table shows the Rouge 2 and Rouge L recall and F scores. So out of all the domain specific methods, both supervised and unsupervised, we see that DELSUM performs the best for all the measures. While comparing with supervised domain independent methods, we see that DELSUM outperforms both SummaRunner and BERTSUM. The difference with SummaRunner in Rouge 2 is not statistically significant. Note that DELSUM is unsupervised, whereas SummaRunner and BERTSUM were trained on 7,100 documents. Next, we do a segment-wise performance evaluation. So in this table are the segment-wise Rouge L F scores of all the methods. So values in red underlined are the ones which are less than 0.3, and the best value for each segment is in green bold. So as one can observe that DELSUM performs best in 3 out of the 6 segments, and overall it achieves a balanced representation of all the segments in the summary. Especially DELSUM performs better for final judgment and issue, which are the most important segments in the summary. These are also the shortest segments. Other algorithms with no domain knowledge completely misses these segments. So we have more analysis and intuitions in the paper. So till now, we have been using expert assigned rhetorical role labels for summarization. But in a practical scenario, it is not possible that sentences in the input case documents will be labeled by the experts. So in this experiment, we use a state-of-the-art model to first rhetorically label the documents and then feed them to DELSUM. So the results show that the performance does not drop much, even when the rhetorical labels are around 80% accurate. Let us now give a brief note on the generalizability of DELSUM. So DELSUM is generalizable to documents from different jurisdictions as well as different stakeholders like law practitioners, students, etc. So this is because DELSUM is quite customizable, and this is through the different parameters like the segments and weights of the segments can be defined by whoever is using this algorithm. Also, the minimum number of sentences from each segment can be given as input. Finally, the content words and what will be the weight of these content words can be decided by the different stakeholders. DELSUM can be modified to include various guidelines. For example, if a stakeholder or jurisdiction wants the summary to have facts and final judgment, then WK and NOSK should be kept higher for K is equal to facts and final judgment. Similarly, if there is a use case that the statute sentences should be more than the sentences with noun phrases, then the score of the statute words can be kept higher than the score of the noun phrases. So to conclude, in this work, we propose DELSUM that can efficiently encode domain knowledge for extractive summarization of legal case documents. We show that it is necessary because important segments like final judgment and issue gets missed in otherwise unguided algorithms. DELSUM achieves a balanced representation and it can also handle redundancy efficiently. It is also generalizable to different jurisdictions and stakeholders. So as a future work, we plan to explore how these otherwise hand-tuned parameters of DELSUM can be automatically derived, how the weights can be automatically derived. So our implementation of DELSUM is publicly available. I would like to conclude by acknowledging the law experts from the Rajiv Gandhi School of Intellectual Property Law, India, TCS for their fellowship, the Mirror EU project, and Complex Networks Research Group, IIT Kharagpur. Thank you, and I can take questions now.
Thank you very much, Paheli. Well, we have one question for you from Marcela Lopez. Do you have any hypothesis that could explain why the unsupervised algorithm you developed outperformed the supervised learning models?
Yeah, okay. So the supervised training algorithms depend on the kind of data they are given to summarize. I mean, the learning process depends on what kind of data they are given. So maybe the summaries which we collected from our website, maybe their quality did not adhere to the guidelines of what the legal experts tell us. So maybe that is a reason why the supervised methods did not perform well.
Okay, thank you very much. Do you have any other considerations or few words to finish it?
No, it's fine. So thank you everyone for your attention, and please go through our paper, and if you have any questions, you can get back to the authors, me and the other authors. Thank you.
Okay, thank you very much. Well, now we will have 1 hour break, and those who want to meet other participants and exchange experience can access the GatherTown platform for a networking moment. The link is at the OpenFi platform. Thank you very much and see you soon. Bye-bye.